Hello, everybody. It's great to see you all in this standing room only crowd, literally standing room only crowd. To celebrate Daphna Renan's appointment as the Peter B. and Mary J. Munroe Professor of Law. So let's give Now, before I introduce Professor Renan, I want to say just a few words about the professorship and about the wonderful generosity of the late Peter and Mary Jean Munroe. So Peter was born in Detroit in 1918. He was a lifelong resident of Lansing, Michigan. And after starting his career with the Michigan State Accident Fund in 1971, he and a partner started their own firm in East Lansing. Peter was known as a hardworking and impactful lawyer, a person of principle and integrity throughout his life, and I will say he lived to be 100. Peter was very civic-minded. He was an active member of the ABA and of the Michigan State Bar, and he was honored for his excellence as a lawyer. Mary Jean Munroe was born in 1918 in Lansing and graduated from Michigan State. Peter and Mary Jean met in college. After college, Mary Jean worked for the Polaroid Corporation in Cambridge so that Peter could attend Harvard Law School. And when Peter and Mary Jean returned to their beloved Michigan, Mary Jean worked for the superintendent of the East Lansing Public Schools for 43 years until her retirement. Mary Jean lived to be 97, and she and Peter were married for 76 years. In 2019, Harvard Law School received an extraordinary gift from the Peter B. Munroe and Mary J. Munroe Trust to establish both this chair and an endowed scholarship fund. Their foresight, planning, and generosity will have a tremendous impact on generations of scholars and of students. And tonight, here representing the Munroes, we have Bill and Mary Housefield. Bill, who was Peter's law partner, is a magistrate for the Michigan Workers' Compensation Board of Magistrates and has served as the executor of Peter's and Mary's estate and as trustee of their trust. We are deeply grateful for his assistance in helping to make Peter and Mary Jean's philanthropic objectives a reality. Thank you, Bill. Please join me. And now I want to say some words about our wonderful colleague and friend, Daphna Renan. In less than a decade as a law professor, Professor Renan has established herself as a leading scholar of the presidency and of constitutional democracy. What makes Professor Renan's work so powerful and so impactful is that she is able to combine conceptual rigor with a deep grounding in the way institutions actually work. Professor Renan has helped us understand how norms shape executive power, about the important legal distinctions between the president as a person and as a government official, and about the way the president structures legal advice, the legal advice they receive, and how that shapes our shared aspiration to be a government of laws. And now, working with our colleague Nico Bowie, Professor Renan has moved on to explore the role of the judiciary in a constitutional democracy and the paramount authority of the people acting through Congress to compose our government and our democracy. It's such important work. It's exceptionally well done, and it's already reshaping the way we think about our constitutional order. In addition to bringing brilliance, creativity, and principle to her scholarship and her teaching, Professor Renan brings amazing experience. She served as counsel to the Deputy Attorney General and as attorney advisor in the Office of Legal Counsel, both in the U.S. Department of Justice. She also served as a member of President-elect Obama's Justice Department transitions team, and all of this came after two terrific clerkships, one for Justice Ginsburg and one for Judge Edwards on the D.C. Circuit. This experience perhaps helps explain the deep insight that Professor Renan brings to understanding and illuminating the institutions of the U.S. Constitution and U.S. democracy. Professor Renan is also an amazing teacher, mentor, colleague, and friend. She skillfully teaches our 1Ls, many here today, legislation and regulation. She is not only a great teacher, but also a generous mentor to our students. I know all this firsthand, by the way. I've had the great honor of teaching the public law workshop with Professor Renan multiple times over the years. Not only do our students learn a lot from her, I do too. And on top of all of this, Professor Renan has been a wise advisor to me and a very important member of our leadership team here at HLS. And I'm so delighted that she's here at Harvard Law School. So, knowing that I'm the only person standing between you and hearing from Professor Renan, I will close, and I want to close by quoting something that Professor Renan once said to the class of 20. She said that becoming a great lawyer requires, quote, humility, humanity, integrity, and imagination. You know, I couldn't agree more, and I cannot think of anyone who better models those values and qualities for our students. So without further delay, I give you the Peter B. Munroe and Mary J. Munroe Professor of Law, Daphna Renan.
Admit that I'm a little overwhelmed seeing all of you guys here. I'm so grateful, and I also just want to invite the students, if you want to, feel free to take seats in the front, and I promise I'm not cold calling during this talk. The chair lecture is a pretty rare opportunity in legal academia to express some gratitude, and I feel just enormous thanks for a lot of the people in this room. So I wanted to take a few minutes at the outset just to express some deep felt thanks. Starting with Bill and Mary, it's really an honor to carry forward Peter and Mary Munroe's name in this way. I did a little research, and I was initially a bit concerned to learn that Peter was elected to his high school student council on an Ignore the Faculty platform. But everything I read makes clear that he's someone of just such immense integrity, that he was such a treasured part of his community, that public service meant so much to him. And so it really means so much to me to carry forward his name in this way, and the incredible partnership that it sounds like he and Mary had. When students come to me and ask me for advice, especially as a woman in the legal profession, one thing I always say is pick a good partner. And it sounds like they had a really tremendous partnership. I also wanted to say thanks to Dean Manning, who I met when I was just weeks on the entry-level market myself. And you have been just such an amazing mentor and supporter and friend from those first days. And it's been so fun to get to collaborate with you and co-teach with you, and I'm so grateful for everything. To all the faculty colleagues here who've read so many versions of drafts of papers and talked through ideas over the years, I'm endlessly grateful for that, and I know how much stronger my work has gotten as a result of it. And there's also some colleagues here who we kind of grew up together as law professors, from our first days teaching together, swapping teaching notes and very first drafts. And I always say to the students to invest in each other, and that doesn't stop. And so I'm so grateful to see you guys here as well. And Nico, who's the greatest collaborator, who you're going to hear a little bit more about in a moment. I also want to tell the incredible students that I'm so touched to see so many of you here, and it is truly the greatest privilege every day to get to teach and learn from all of you. And some of you who've done just unbelievable research on various projects might see some of your research talked about in the remarks today. My family. So my 4-year-old Nate thinks that Paw Patrol is more important than either federal authority or judicial supremacy at the moment. So he's at home, but he's always in my heart. And my daughter Izzy who's 9. So I was pregnant with Izzy when I wrote my first Law Review article. So Izzy's life and my academic life are almost entirely coextensive. And Abby and I were just remembering that from when Izzy was a toddler, she would be sitting at her little arts and crafts table and telling me that she was busy working on her article. So it's been a shared process. Izzy with some sacrifices in terms of sleep and time together along the way, but also I just get endless inspiration from your boundless curiosity and also the creativity that your generation is going to need to have to tackle the problems that lie ahead. And last but certainly not least, I just want to say to Larry, thank you for everything. I take 76 years now as a challenge. So my work over the past decade has focused on excavating the features of and developing a normative argument for federal authority without judicial supremacy. So I thought I'd use this lecture to pull some of those threads together. And doing so has also given me a bit of a chance to reflect on how that project has unfolded over time. So I'll begin with federal authority as a source for power for and from the presidency and explore the contours of executive branch legalism and its implications for constitutional governance. And then I'll move from presidential power to the separation of powers and advance an argument against a jurisdicratic separation of powers and in favor of a more political conception of the separation of powers. So one grounded in the messy, the contingent, the provisional practices of Congress and the presidency. And finally, I'll move from the separation of powers to American constitutionalism more generally, to defend a commitment to federal authority and to the ongoing development of national constitutional commitments, but without judicial supremacy. So without the authority of the Supreme Court to have the final say on what the Constitution means or requires. And my recent work, beginning with the separation of powers and extending to constitutionalism more generally, has been an ongoing collaboration with a treasured colleague and a dear, dear friend, Nico. And so the remarks are very much a reflection of our shared thinking and ongoing research and conversations. And it's hard to overstate how intellectually rewarding, generative, and fun it's been to get to collaborate with Nico on this set of projects. We're knee-deep in research for a new book, and this talk is going to preview for the first time some of the ideas and sources that we've been collecting in connection to that project. So across these moves from presidential power to the separation of powers to American constitutionalism more generally, I want to suggest that analyzing federal authority without judicial supremacy brings into view a different perspective on what constitutionalism can be, what makes it valuable, and what role federal actors, including but not centered on federal courts, can play in meaningfully constructing it. So I'll start with the president. And what does constitutionalism look like inside the presidency? If we think about the institution of the presidency over time, how does the president structure the work that lawyers are doing day in, day out to assess, to sanction, to orient presidential practice, to make it more attuned to federal law? So the dominant conception in the literature, at least aspirationally, is what we might think of as a court-like structure. A quasi-judicial actor that provides the authoritative constitutional understandings of the executive branch. And on this telling, legal review is centralized inside the Office of Legal Counsel, which is an office inside the Justice Department that's relatively insulated from the pressures of the presidency and the broader White House complex. And some would like to see it even more insulated from the presidency, more independent. And OLC issues formal and authoritative legal opinions resolving specific disputes, and thereby decides the kind of binding constitutional understandings of all the actors inside the executive branch. So we can think about this approach to legal policy as articulated, to borrow a term that Jeremy Waldron has used in the separation of powers context, in that it involves sequential phases of governance with a court-like adjudicator that's deciding what the Constitution means for the executive branch as a whole. And unless overturned, those legal opinions, that body of executive branch precedent, is the final say on what the Constitution will require or tolerate. So my work has really resisted that model, both as a description of what legal review looks like inside the executive branch in a lot of high-stakes policy domains, and also as a normative account of what the aspiration of constitutionalism should be inside the executive. So I argue that the model did have kind of a brief heyday, and a Justice Department still reeling from Watergate, but that its institutions proved quite unstable, and that a very different model has also become quite prominent, what I called porous legalism. And in some ways, porous legalism is a rejection of the kind of articulated mode of constitutional governance that is at the center of this OLC supremacy model. So instead, this is a more intermingled and more porous approach to executive branch legal review. And by porous, I don't just mean that questions of law implicate questions of policy, which is always true to a point, but that the institutional apparatus actually does less to insulate the lawyers and the kind of legal considerations and the legal process from policymakers and policy considerations. So to use an analogy from administrative law, we can think about this as a kind of chevron space. So as an idea of legalism, my former students know, my current students are soon to find out, chevron signifies a kind of move away from one right legal answer to a range of permissible legal possibilities. And at the institutional level, the effect of chevron has been to take the lawyers kind of out of the driver's seat and to permit a more intermingled process among lawyers and policymakers and political actors to interpret federal law in the service of federal policy commitments. So the analogy to chevron isn't perfect because chevron is a doctrine of judicial review, and it's about courts interpreting the permissible bounds of statutory regimes. And here we're, of course, talking about legal review entirely outside of the courts and relating to both statutory and constitutional questions. But so you might think of this more porous legal judgment as a kind of chevron all the way down. So at an institutional level, this more porous legal judgment unwinds some of the core commitments of the more court-like model, in the sense that there's a diffusion of legal responsibility, a broader kind of more shared commitment to making sense of the law, of statutes, and the Constitution. And also a decline in formality. So we saw actually a striking decline in kind of formal published legal opinions coming from within the executive branch and deciding what the meaning of the Constitution entails. Now, each model, I think at times, can and has enabled rigorous legal analysis of really hard questions that the executive confronts. And each has also been exploited in significant and problematic ways by different administrations over time. But the two models also have distinct risks, and I think maybe even more relevant for my purposes here, I think they help to realize very different affirmative visions of constitutional governance. So in terms of the risks of quality of the legal advice, with porous legalism, we might worry that it leads to forum shopping inside the executive, meaning that the president can kind of see what different lawyers think and pick and choose interpretations that help advance a particular policy or political goal. And to the extent that there's group dynamics, that might lead to a consensus that's less epistemically robust than we might want it to be. But the court-like model has significant risks as well, and my work has argued against essentializing constitutionalism or suggesting that it must have this more court-like quality. So I think OLC supremacy can lead to political or ideological capture, including by lawyers with relatively extremist views of constitutional power. And it can then endow outlier legal views with tremendous institutional power. And I think we saw that in the aftermath of 9/11 inside the executive branch. And I think we're seeing something similar today in the institution of the Supreme Court. OLC supremacy can also be implemented in ways that exclude other agencies with relevant expertise and knowledge, and with a deep sense of the moral and policy and humanitarian stakes on the ground. But it's not just that the risks are different. I think the two models also privilege two very different ideas about constitutional judgment. So OLC supremacy sees this kind of judgment in the literature as kind of uniquely, dispositionally or professionally a legal judgment, the work of lawyers and legal analysis. And under porous legalism, lawyers are in some ways more pervasively infused in the apparatus of governance, but law maybe plays a more marginal role in any particular policy decision. So the institutional structure facilitates a more blended or intermingled legal and moral and policy assessment. And I think this more porous moral and legal and political and policy judgment can be quite valuable, especially in contexts where there really aren't clear legal answers, and the humanitarian and moral and policy stakes can be quite high. So in some ways, porous legalism reflects the trajectory of the administrative state itself and its shift away from a kind of adjudicatory approach to disciplining discretion and to building legitimacy in governance. And the domain of a court like OLC, though still very relevant in some areas, has shrunk. And I think that trend suggests a less legalistic constitutionalism, and more fundamentally, the possibility of a more provisional understanding of the Constitution itself. That provisionality, that revisability, is something that I think we should preserve, not gut. The Constitution as a site of ongoing political contestation, not quasi-judicial resolution. So this is a kind of legal review outside the courts, but it's also a kind of executive branch constitutionalism that discards of judicial supremacy as its guiding tenet or lodestar. So is this more porous legalism, this more kind of blended moral, legal, political judgment available, and is it desirable as a mode of constitutionalism beyond the presidency? So Nico and I argue that it is, and that a more porous legalism in the separation of powers context would help to recover some important Republican values in the sense of neo-Republican theory underlying our institutions of constitutional governance. So rather than treat the separation of powers as a legalistic principle or a set of interbranch entitlements that get secured by judicial definition and preservation, we argue that the separation of powers should be understood as a contingent and provisional political practice that reflects the policy needs and the governance ideas and the political struggles of the moment. It involves a set of broad and vague and conflicting and contested political ideas about checking and also enabling governance and about allocating power, and a set of interacting institutions that have to participate in this messy work of building the state and building the state's capacity. So federal statutes on this account are foundational to the design of constitutional government, but not because statutes comprise some evidence of a settled constitutional understanding or of an interbranch acquiescence, but rather because federal legislation constitutes the separation of powers that exists. It offers a durable, though not immutable means of building the state. And it makes possible the creativity and the compromise and some of the inescapable messiness and dysfunction of the political process itself. So normatively, this understanding of the separation of powers is a challenge to what we think about as the juristocratic approach that emerged in the early 20th century in the long shadow of the lost cause. So we've traced how the court's current conception of the separation of powers as a set of rigidly defined legal limits on how Congress and the president can work together to create federal legislation that designs the administrative state, and that kind of sees it as the singular authority and responsibility of the Supreme Court or the court to police those legal limits. How that conception, which really comes to life in the Myers case in the 1920s, emerges out of the grips of this lost cause zeitgeist, where there's this worry that it was really part of a revanchist reaction to Reconstruction and a dogma of fear about what a radical Congress could achieve in creatively trying to expand its constitutional powers to build a multiracial democracy on the ground. And it's this juristocratic separation of powers that today is still quite dominant on the Supreme Court. And as a normative matter, our rejection of the juristocratic separation of powers is in part a rejection of a substantive conception of the separation of powers as fixed. We think there's exceedingly little that should be regarded as fixed or defined in the constitutional allocation of power between the political branches. And the design of the state at the level of the institutional interactions between the executive and Congress is a story really of episodic settlements and recurring contests. And the structure of the national government has changed over time, in part to accommodate our changing substantive and political expectations for what it is that the state should be able to achieve, what it is that the state should be able to do. So put differently, the separation of powers is not a system of clearly defined legal entitlements. It's a process of inescapable, ongoing contestation about what those national commitments should actually look like on the ground. There's no ideal or essential allocation of power between Congress and the presidency. And this fundamentally unsettled constitutional structure is not a problem that courts should be trying to solve or to resolve. It's a central and desirable feature of American constitutional government. By contrast, we worry that a juristocratic separation of powers leads to a kind of judicial domination. So it inhibits our constitutional imagination by forcing everyone else to phrase what matters to them about the separation of powers in the legalistic terms of the reigning court majority. And it undermines rather than realizes the rule of law. So the court normalizes the president's violation of federal statutes in defense of deeply contested ideas about the separation of powers. And in so doing, the court makes it more acceptable and more expected to have a president that violates federal laws, and so more difficult to hold the president to the president's power to account. Perhaps most fundamentally, we think this juristocratic separation of powers displaces legal entitlements for political morality in the grammar of our constitutional discourse. So it incentivizes kind of abstract and absolutist claims of legal right instead of an effort to achieve political accommodations for a working national government. Now, Nico and my current book project is an attempt to extend both this historical and this normative work to the project of American constitutionalism more generally. And we're currently tracing the roots of a more political constitutionalism in the United States to the political abolitionism of the early and mid-19th century. So in the 1830s to 1850s, abolitionists are agitating to abolish slavery and to build for the first time a meaningful multiracial democracy in the United States. And we argue that their work provides a template for a Republican theory of constitutional government. So one that depends on the institutions of representative democracy rather than the power of a supreme judicial tribunal to build political equality on the ground. For many of these abolitionists, the Supreme Court is, in the words of Theodore Parker in 1858, a judicial revolver in the Southern hand. And on this perspective, the Constitution is emphatically not what the Supreme Court says it is. The perils of juristocracy and the promise of a more political constitutionalism come to a crescendo in the reaction to the Supreme Court's Dred Scott decision. So that's the decision that holds that a Black person enslaved or free can't be a citizen of the United States, and that rejects Congress's power to abolish slavery in the territories and thereby strikes down federal legislation that's not related to the court's own authority for the first time in American history. And Frederick Douglass urges in response, he responds to the Dred Scott decision. He says, "I have no fear that the national conscience will be put to sleep by such an open, glaring, scandalous tissue of lies as this decision is and has been shown to be." Douglass says, "We can appeal from this hell-black judgment of the Supreme Court to the court of common sense and common humanity." So Douglass then goes on to emphasize the difference between the US Constitution and constitutional doctrine that the Supreme Court is creating. The Constitution is one thing, Douglass says, its administration is another. And in this instance, it's a very different and opposite thing. I am here to vindicate the law, he says, not the administration of the law. When Douglass develops this position, he's taking up and advancing a line of argument that's been unfolding over the course of decades, including in the context of the Colored Conventions movement, which was a centerpiece of Black organizing in the early 19th century. So that by 1851, at the Ohio State Colored Convention, a political abolitionist could say to his co-delegate who's pressing to abandon the Constitution and to refuse to vote or to participate in a government constituted under the Constitution, this political abolitionist in 1851 can say, "Don't make the construction of the Constitution the same as the Constitution itself. There's no dispute between us in regard to the pro-slavery action of this government, nor doubts in our mind about the aids which the Supreme Court of the United States has given to slavery by their unjust and, according to their own rules, illegal decisions. But that's not the Constitution. That's not the Constitution under which I vote." So these abolitionists are not only rejecting the supreme authority of the Supreme Court to say what the Constitution is, they're also rejecting the modes of interpretation that are being used in Supreme Court decisions. And they're starting to develop their own modes of legal interpretation. So Gerrit Smith and other political abolitionists of this period are developing what today we would call a substantive canon of interpretation in favor of political equality or in favor of more egalitarian readings of the Constitution and federal statutes. And he's anchoring this substantive canon of interpretation in the Declaration of Independence and in the commitments reflected in the preamble of the US Constitution and in the guarantee of Republican government. And they're arguing for something like what we would today say is a clear statement rule. So they're arguing that there needs to be a clear and unambiguous statement for any law to be construed in a way that would favor slavery or white supremacy. And as Douglass puts it in 1857, and he's building here on Gerrit Smith's earlier work, he says, "When I admit that slavery is constitutional, I must see slavery recognized in the Constitution. There must be no room for doubt. There must be no other possible way to read these provisions in the Constitution or the statutes." And Douglass's own evolution coming to this position is really deeply influenced by, very much in conversation with political abolitionists like Smith and others who in the early 1850s are developing a set of legal rules for interpretation and a defense of the authority of actors beyond the Supreme Court, and in particular the authority of Congress to participate in the work of constitutional construction and constitutional building of a multiracial democracy. So that in 1883, writing in response to the unfortunately named civil rights cases, which struck down as unconstitutional the Civil Rights Act of 1875, and writing a year before James Bradley Thayer first articulates this argument, Frederick Douglass urges, "Now, when a bill has been discussed for weeks and months and even years in the press and on the platform, in Congress and out of Congress, when every argument against it has been over and over again carefully considered and fairly answered, when its constitutionality has been discussed pro and con, when it's passed the House of Representatives, passed the US Senate, been signed by the President of the United States, exists in our statute book, you will agree with me that the reasons for declaring such a law unconstitutional and void should be strong, irresistible, and absolutely conclusive. So this is an idea that we today associate with Thayer, but which political abolitionists had begun to develop well before Thayer's famous Harvard Law Review article, or even his first expressions of this idea in 1884. So how should we understand the constitutionalism of political abolitionism? This is a constitutionalism that's messy, creative, contested, engaged, provisional, porous, in the sense of this blended moral, political, legal policy judgment. It serves political means of building solidarity and a site for constituting a national constitutional identity that centers equality and belonging. And it has force on the ground. So the rejection of judicial supremacy advanced by political abolitionists and ultimately embraced by mainstream Republican politicians is what makes possible the rejection of slavery in the United States. But this rejection of judicial supremacy also does something else. It also makes possible a kind of federal authority constituted by statutes, by a mix of creative and assertive and expansive protections of federal constitutional guarantees as understood by members of Congress, as debated by members of Congress, driven not just by legal ideas, though in part by legal ideas of congressional responsibility, but also by moral convictions and policy goals and the need for political compromise. And building on these foundations of political constitutionalism, Nico and I are arguing for a more political constitutionalism in our own time, so one that rejects the final say of the Supreme Court while redoubling efforts to develop and to secure federal constitutional guarantees of a more egalitarian system of government through the instruments of Republican self-rule and representative democracy. Now, Congress can't implement these statutes on its own. It can't make real the national constitutional commitments that it's articulating and that it's striving to secure without enforcers on the ground. And both those in favor and those deeply opposed to the project of Reconstruction are deeply attuned to this. So when Congress passes the Civil Rights Act of 1866, which for the first time declares all persons born in the United States to be citizens of the United States irrespective of race, the Baltimore Sun comforts its white readership that the bill does not execute itself. Have no fear, this bill can't execute itself. But Congress can empower other actors, and the Reconstruction Congresses did give, through federal legislation, to federal courts and to executive branch actors the statutory power to engage in a kind of constitutional common law, to implement these national commitments as they best understand them. So we argue that this is an authority to interpret the Constitution, but it's a judicial authority by grace of Congress. And Section 1983 is an example of that kind of statutory power. So it's the vehicle, it's a remnant of the Reconstruction Acts, and it's a vehicle through which the court has elaborated significant constitutional understandings in cases ranging from Brown through Roe, through Obergefell. But these landmark cases, while they're invalidating state laws, the court is following, it's not annulling congressional instructions. So these kinds of decisions don't represent judicial supremacy, they represent Congress's ability to commit to constitutional understandings and to rely on federal courts as implementers of those commitments. By enlisting federal courts and implementing that authority on the ground, Section 1983 is creating a kind of constitutional common law regime. But this doesn't eliminate Congress's authority to disagree and to offer a countervailing account of what those constitutional commitments should look like when Congress deems the courts too stingy or too unconvincing. So in that sense, judges implementing Section 1983 are exercising a kind of common law power. They're building constitutional meaning in the process of deciding cases brought under Section 1983 because that's the federal legislation that has authorized them to do so. But since this is a kind of constitutional common law by grace of Congress, it means that Congress can also reject the constitutional understandings that it disagrees with. It can treat the court's constitutional work as provisional. So Congress can legislate its own understandings, including, and we agree with Larry Lessig on this in terms of what the privileges and immunities of citizenship should look like, and it can limit the power of the court to intervene in ways that Congress thinks are a threat to its constitutional commitments. So if the political abolitionism of the early 19th century brings into view this kind of promise of political constitutionalism, some of the present-day remnants of the Reconstruction Congresses, like Section 1983, help offer the tools to rebuild it on the ground. And as Section 1983 illustrates, political constitutionalism is not a rejection of judicial power. It recognizes federal courts as relevant actors in implementing national constitutional commitments established by federal law. But political constitutionalism does discard of judicial supremacy. It rejects the court's authority to have the final say on what the Constitution means or tolerates. When the court makes constitutional law, in reality it's implementing a set of interlocking federal statutes, statutes about the court's jurisdiction, about the causes of action that are available, about the remedies that are available, about the substantive commitments that are provided by federal law. And Congress can adjust, it can rethink, and it can revise the federal court's authority along any of these dimensions. And it has done just that in the past. So when we think about the Supreme Court making constitutional law, what the court is typically doing is implementing federal statutes. So if I started with an administrative law analogy to Chevron, let me end with one to Brand X. And my former LegReg students will remember, and my current LegReg students, you have something to look forward to for our last week of class, that Brand X is the case that says that where there's a judicial construction of a statute that an agency administers, that judicial construction is only provisional. So if the court later is confronted with a different interpretation of the statute from the agency, the court has to recognize, if reasonable, that alternative construction of the statute. And implicitly, Brand X is making space for this more porous, this moral, policy, political, and legal judgment about what the statute should mean in the context of present circumstances. Now, Brand X itself might well be overturned, and the current court is rapidly shrinking the space for this kind of porous judgment under Chevron as well. I think that just shows how much work we have ahead of us in building and defending this alternative conception, not just of federal statutory interpretation, but also of a constitutionalism that lets go of our commitments to judicial supremacy. This kind of constitutionalism understands our founding document as a site for political contest, for dissensus, for power sharing and power building, and for community building. And it recognizes that our constitutional rights are only as secure as our politics can make them. So to build a better politics, we have to give the Supreme Court a little less control over what our polity can look like. We have to reject the idea that judicial supremacy is an essential ingredient to federal authority in the United States. Thanks so much. kindly been standing for close to an hour, so I'm happy to take a couple of questions or to say thanks for standing for so long. Or to say read Nico in my book when it comes out. Mike.
So the abolitionists and Douglas are making arguments about judicial supremacy in a particular context. Fred Scott is saying that their whole enterprise is unconstitutional, the court's framed on the Civil Rights Act. You and Nico are also making arguments in a particular context. So how much are you embracing an abstract idea about limited judicial supremacy, and how much are you arguing against what most of us would regard as the most conservative court in 100 years?
So, I think the honest answer is we're doing both. And one thing that has been just interesting to me in putting together the notes for this talk is to see how the argument has developed in my own mind over time, from a kind of a less court-centric view of constitutionalism in the executive to a worry that for a long time the court's been building this overly legalistic understanding of the separation of powers that's really incapacitating the potential for experimentation in the administrative state. So I've come to these ideas slowly and over time in a way that has built in my own mind a real skepticism of judicial supremacy. But I think part of what we're seeing is the danger of judicial supremacy run amok. So I think the kind of power that we've given the court to decide our most contested, most deeply felt commitments has put a strain on the appointments process that is hard for the appointments process to bear, and it's kind of intoxicated what the politics around the court looks like, and it has led to the current court that we have that I think is allowing a particular and in a lot of ways a really outlier view of what the Constitution means to disable really vital federal legislation from Shelby County, Citizens United. I think that we don't have to, the Reconstruction era is so valuable for us because it's a microcosm of things to come, but I think we've continued to live in that kind of dangerous state of what happens when we give the court that kind of power. So that's very much, I think we can't disentangle the moment that we live in from the broader commitments, but they're both very much alive in this project. Yeah, Larry.
So how much faith do we have to have in Congress?
Yeah, fair enough, because I don't have much faith in Congress. And you know what, neither did the political abolitionists, because they were talking and writing in the context of the Fugitive Slave Act of 1850, right? Congress wasn't doing such great things at that time either. And so part of what Nico and I are arguing for is that if what we want is to see a kind of richer, more meaningful multiracial democracy on the ground, the question is, how do we get there? Is it by giving more power to democratic politics, or is it by giving more power to the Supreme Court? And you don't have to think that either institution looks especially good at this moment to think that what we need is a little bit more space for creativity and what national government can look like and what kind of federal statutory protections can exist with respect to voting rights, with respect to the whole host of ways in which our democracy is constructed on the ground through anti-discrimination laws and what they cover. And so enabling a Congress to have that kind of authority, kind of letting go of the idea that the court has the final say, that doesn't promise to us a better constitutionalism, but it gives us more agency in our politics to get there, as opposed to kind of waiting for someone to die on the Supreme Court. It allows us to organize, right? To try to vote for people that we think will do a better job in Congress and focus energies on the legislative reforms that we want to see happen, and to not kind of hold our breath for what the Supreme Court will do on issues that are vital to us, like abortion in this country, right? It's going to take politics. It's going to take boots on the ground to protect the right to abortion, and we kind of lulled ourselves into thinking otherwise for a long time. Oh my goodness, Izzy, do you want to have the last question? Nico, we need a dictionary, not just an appendix. When we write the book. Yes, Lizzie, you got it. Perfect. Thanks so much.
Now, before we go next door for some beverages and food, we have a gift to present to the honoree. Now, I don't want anybody to guess what it is. I will just say I'm a textualist, and this is a chair lecture. And so, Professor Renan, would you like to bring your family up to unveil your gift?
It's not a dictionary.